Tonight, what we are looking at is not just a string of bad headlines for Donald Trump. It is not just one courtroom setback, one angry filing, or one more ugly confrontation between the Trump political project and the federal judiciary. What we are looking at is a much larger constitutional problem. What happens when a president or a former president who still dominates national politics begins to treat courts not as binding legal institutions, but as obstacles to be discredited, delayed, or politically overrun, because that is the real issue here. The question is no longer simply whether Trump lost in court. The question is what those losses reveal about the legal limits of presidential power, the resilience of the judiciary, and the condition of the American rule of law system when it is placed under deliberate political pressure. The text we are working from describes 3 court victories in 3 days against Trump-aligned actions, and it frames them not as random defeats, but as part of a larger pattern in which the administration has repeatedly overreached and then been stopped by judges applying relatively basic constitutional principles. It also describes a broader pattern in which the administration is said to be losing roughly 70 to 80% of the time in litigation, at least by the estimates of the litigators challenging it. That number matters less as a scorecard than as a signal. It suggests not merely controversial policymaking, but repeated legal vulnerability, and that is where a serious legal analysis has to begin. In a functioning constitutional system, the executive branch is allowed to be aggressive. It is allowed to test legal boundaries. It is allowed to adopt ambitious interpretations of statutes and of executive authority. But there is a line between aggressive lawyering and constitutional lawlessness. And once courts begin repeatedly telling the executive branch that it has crossed that line, the legal story changes. At that point, the issue is no longer one of mere policy disagreement. It becomes a question of institutional discipline. That is especially true in the first cluster of cases described in the text, Trump's executive orders targeting major law firms. If the summary in the text is accurate, these orders attempted to revoke security clearances, cancel government contracts, and even restrict lawyers from entering federal buildings and courthouses based on the firms they worked for or the clients they represented. The legal analysis in the text is blunt. Multiple federal courts rejected these efforts as unconstitutional, with courts finding violations of the First Amendment and of the Fifth and Sixth Amendments, including the constitutional guarantee of access to counsel. The text emphasizes that these were not close calls and that judges appointed by both Republican and Democratic presidents rejected the effort. That point is crucial. A lot of political commentary about the courts focuses obsessively on which party appointed which judge as if that alone explains outcomes. But the transcript repeatedly undercuts that narrative. It notes that these rulings came from judges appointed by presidents of both parties and argues that the outcomes were driven not by ideology, but by basic constitutional structure. In other words, these were not judges freelancing politically. These were judges enforcing very old legal principles, and those principles are not obscure. The First Amendment does not allow the government to punish people or institutions because of protected expression or association. The Fifth Amendment protects due process. The Sixth Amendment protects access to counsel in criminal matters. And the broader constitutional order depends on the availability of independent lawyers willing to represent unpopular people and causes. The text makes the point powerfully that lawyers cannot be punished for who their clients are or for arguments they make in court. That is not some technical rule for elite professionals. That is one of the conditions that makes adversarial justice possible in the first place. So when courts block executive actions that target law firms in this way, they are doing more than protecting a profession. They are protecting the architecture of legal representation itself. And once you understand that, the gravity of the conflict becomes clearer. If a president can use executive power to punish lawyers and firms for disfavored representation, then the right to counsel becomes conditional. It becomes available only to those whose representation is politically safe. That would be catastrophic for constitutional order, because the whole point of a legal system is that even the hated, the accused, the controversial, and the politically toxic can still obtain representation. The transcript even invokes the deep historical tradition of lawyers representing unpopular clients going back to the founding era. That is not romantic rhetoric. It is a reminder that the legal system survives only if advocacy is protected from government retaliation. Now look at the executive branch's behavior in the aftermath. According to the text, the Department of Justice at one point appeared prepared to withdraw appeals after suffering multiple defeats, then allegedly reversed course after presidential anger over media coverage. The summary describes the DOJ as first trying to walk away from appeals and then walking back the walkback after Trump became upset. It also describes a 97-page filing signed largely by political appointees and characterizes the government's behavior as an attempt to prolong another loss rather than defend a legally sustainable position. If that account is fair, it raises a deeply uncomfortable rule of law question. Is the Department of Justice acting as a legal institution or as a political damage control mechanism for presidential grievances? That distinction matters enormously. DOJ lawyers are not supposed to be personal enforcers for the president's private resentments. Their obligation is to the law, to the Constitution, and to the institutional integrity of the United States. If litigation decisions are being driven by a president's reaction to headlines rather than by sober legal judgment, then the problem is no longer just overreach. It is corruption of legal process. And then there is the second major legal theme in the text, precedent. One of the speakers in the transcript makes an important and accurate point. Trial court rulings do not bind every other court. They are not nationwide precedent in the formal sense. But once a federal court of appeals affirms those rulings, something larger happens. Now you begin generating controlling appellate precedent, at least within that circuit. That means a bad executive idea does not just lose once. It can become affirmatively fenced off by doctrine. The transcript suggests that by pursuing appeals in weak cases, the administration may actually be helping to create stronger precedent against itself. That is an underappreciated feature of constitutional conflict. An executive branch can lose a case and move on, but if it insists on escalating a losing argument, it may end up strengthening the judiciary's long-term ability to restrain future abuses. In that sense, every appeal carries two risks for the administration: the immediate loss and the creation of durable doctrine that limits presidential power more broadly. The transcript's discussion of the Supreme Court is also revealing. One speaker questions why the court would even want to take up some of these disputes because the law is described as well settled. That matters because not every conflict involving Trump is a grand, unresolved constitutional mystery. Some of these cases, if the transcript is right, involve relatively straightforward violations of settled rights. And when a government repeatedly pushes obviously weak theories, courts begin to see a pattern, not creative constitutional argument, pattern, not statesmanship, pattern, not democratic experimentation, pattern. That pattern extends beyond the law firm litigation. The transcript next describes a ruling by Judge Royce Lamberth involving Voice of America and Kari Lake. According to the text, Judge Lamberth found that Lake had been improperly leading the agency without Senate confirmation in violation of the Constitution and federal law, and that her efforts to reshape or damage the agency should be given no force or effect. The transcript also emphasizes Lamberth's reputation as a no-nonsense judge who has held government officials and even agencies in contempt when they violated court orders. Why does that matter in a larger Trump versus the courts analysis? Because it is another example of the same structural conflict. The executive branch, or people acting in its orbit, appears to be testing whether normal legal constraints on appointments, confirmation, and lawful service can simply be brushed aside in the name of control. And again, the response is judicial. No, not because the judge is hostile to the administration as such, but because lawful appointment and lawful authority still matter. That phrase matters, lawful authority. The American constitutional system does not say, if you are politically important enough, your authority will be presumed. It says authority must be legally conferred. Titles matter. Confirmations matter. Procedure matters. And once those things stop mattering, the entire distinction between constitutional governance and personalized rule begins to blur. The transcript also highlights another familiar move from the administration and its allies: the reflexive branding of judges as activists whenever they rule against executive power. Kari Lake, according to the text, tried to paint Judge Lamberth that way. The transcript also mentions similar rhetoric directed at other judges, including judges appointed by Republicans and even justices appointed by Trump himself. This is not a small rhetorical habit. It is part of the legal crisis. In a healthy system, activist judge may be a criticism of interpretive method. But in today's politics, it is often used less as a legal argument than as a delegitimizing weapon. The purpose is not to show doctrinal error. The purpose is to teach the public that any ruling restraining executive action is presumptively illegitimate. That is profoundly dangerous, because the judiciary's authority ultimately rests on public acceptance that courts have the right to say no, even to presidents. The more that every adverse ruling is converted into partisan grievance, the harder it becomes for courts to function as courts. The third major area in the text involves immigration and protest-related litigation. The transcript describes a federal court order out of Oregon stopping DHS or ICE from releasing chemical munitions near low-income housing developments, with the court forcing the government to stop after people, including children, became ill. It also describes a separate major ruling blocking an immigration-related policy that allegedly would have deprived many non-citizens, including asylum seekers, of meaningful judicial review and appeals, and notes that the policy had been adopted without notice and comment procedures. These examples matter for two reasons. First, they show that the conflict is not confined to elite institutional fights in Washington. It reaches ordinary people, protesters, immigrants, families, and vulnerable communities. The rule of law is not an abstract contest among powerful actors. It is the practical question of whether the government can use force, procedure, and administrative shortcuts in ways that violate legal protections for people with the least political power. Second, these cases demonstrate that one of the judiciary's central functions is to preserve process itself. Notice and comment rulemaking exists for a reason. Judicial review exists for a reason. Appeals exist for a reason. These are not bureaucratic niceties. They are mechanisms that prevent arbitrary government. The legal imagination of strongman politics always treats process as weakness, delay, red tape, obstruction. But constitutional government treats process as restraint. It is how the state is slowed down long enough to be made lawful. And that is what makes this broader fight so serious. Trump's conflict with courts and judges is not simply a story about personality. It is not merely that he dislikes judges who rule against him. It is that the political movement around him repeatedly treats law as legitimate only when it ratifies power, and illegitimate the moment it restrains power. That is the core anti-constitutional instinct, because the rule of law means something very simple and very hard. The government does not get to be the judge of its own limits. Courts do that, not perfectly, not infallibly, but constitutionally, that is their role. And every time a court says, no, this violates the First Amendment, or no, this violates the appointment structure, or no, this deprives people of judicial review, it is doing exactly what the constitutional order expects it to do. Now, to be fair, presidents often lose in court. That by itself is not abnormal. What makes this different is the repetition, the breadth, and the nature of the positions being rejected. When the same administration is repeatedly stopped across multiple domains for what the transcript portrays as basic constitutional failures, and when the response is not course correction but escalation and delegitimization, then the issue is no longer aggressive governance. It is institutional contempt. And that is where the deepest legal danger lies. A constitutional system can survive policy extremism. It can survive bad arguments. It can even survive periods of intense political attack on individual judges. What it cannot easily survive is the normalization of the idea that courts are valid only when they submit. The transcript suggests that many of these judges are simply doing their jobs, often from very mainstream judicial positions, and that the administration is still losing anyway. That fact cuts through a lot of political theater. If Republican-appointed judges, Democratic-appointed judges, and ordinary district courts are converging on the conclusion that these moves are unlawful, then the problem may not be the judges at all. The problem may be the executive theory being advanced. That is what a serious legal analysis must say plainly. This is not fundamentally a drama about judicial bias. It is a drama about whether American courts still have the institutional will to impose legal limits on a political movement that treats legal limits as optional. And so far, at least in the text you provided, the answer appears to be yes. Courts are blocking unconstitutional retaliation against law firms, Courts are enforcing constitutional and statutory limits on appointments. Courts are preventing administrative shortcuts that would reduce judicial review. Courts are stopping harmful government conduct against affected communities. And litigators challenging the administration believe the government is losing most of the time, but that does not mean the system is safe because constant victories in court can coexist with long-term erosion of democratic legitimacy if the public is taught to see courts as enemies instead of constitutional referees. That is the paradox. The judiciary may be winning cases while losing social trust. And if that happens, then every legal victory becomes harder to enforce politically. That is why this is not just about Trump's losses. It is about what those losses mean. They mean there are still judges willing to say no. They mean the Constitution still has some operational force. They mean the executive branch is not yet free to punish counsel, bypass appointments law, strip review rights, or treat every institutional check as an insult, but they also mean the system is under enough pressure that these reminders are now necessary over and over and over again. And perhaps that is the most sobering conclusion. When the presidency collides with the courts in a constitutional system, the courts are supposed to be boring, predictable, procedural. They are supposed to resolve disputes by applying settled law, but when that routine legal function starts to feel like dramatic resistance, something has already gone badly wrong in the political culture, because a judge saying the First Amendment still matters should not be shocking. A judge saying access to counsel still matters should not be shocking. A judge saying you cannot wield executive authority without lawful appointment should not be shocking. A judge saying the government cannot deprive people of review by shortcuts should not be shocking. And yet, in this moment, each of those things feels dramatic because the baseline has moved. That is the real warning sign. So the story here is not merely that Trump suffered several court losses in several days. The story is that those losses, taken together, reveal a presidency and a political movement repeatedly colliding with some of the oldest legal restraints in the American system: free speech, due process, access to counsel, lawful appointments, judicial review, and the independence of courts themselves. And if those restraints hold, then the constitutional system holds. If they fail, the collapse will not necessarily come all at once. It will come case by case, exception by exception, insult by insult, until the public gets used to the idea that law is negotiable for the powerful. That is why these rulings matter, not because they embarrass Trump, but because they clarify the only question that really matters in a republic. When power says it should not be restrained, are the courts still willing to answer no?